morning, everyone. Welcome to the Threat of Dissent, a public program of the Massachusetts Historical Society. I'm Catherine Allgore. I'm the president here at the Society, and we are so thrilled to have Julia Rose Kraut join us. Not only is she a superb scholar and speaker, but she's one of the family. She was a Friedlander Fellow, and this is part of her work that we help to support. And I'd like to invite you, dear audience, to be a member of the family too. Do go to our website, which is masshist.org, and you'll find lots of delightful things there. Our full public program schedule, there's an exhibition online, the object of the month, there's a blog, all of our doings. But there's also a little part that says support, and if you click on it, you can see how you can become a member of the family, and we'd love to have you. So let's get started with tonight's program. Gavin, will you lead us off?
Sure. Thank you, Catherine. So good evening, and thank you all for joining us for our program today. My name is Gavin Cleesebies, and I'm the Director of Programs, Exhibitions, and Community Partnerships for the Massachusetts Historical Society. I'd like to welcome you to our virtual program. If you have not attended one of our programs in the past, let me mention that MHS is the oldest historical society in America. We were founded in 1791 and have been an independent nonprofit institution dedicated to collecting, preserving, publishing, and sharing our state and our nation's history for the past 230 years. We host both seminars that are geared towards a more academic audience and programs that are meant for anyone who is intellectually curious or has a love of American history. Between our programs and seminars, we host 2 to 3 original events a week. If you enjoy the talk tonight, I hope you'll join us for some of these events or some of the other programs that we have listed on our online calendar. During the pandemic, we are presenting our programs and seminars to the public for free, but we are only able to do this thanks to the support of our members and donors. If you enjoy our programming, I hope you will consider joining or donating to support our work. The program this evening will look at a new book, Threat of Dissent, A History of Ideological Exclusion and Deportation in the United States. We are joined by the author, Julia Rose Kraut. Ms. Kraut is a lawyer and historian who specializes in immigration and First Amendment law and history. Most recently, she was the inaugural Judith S. K. Fellow for the Historical Society of the New York City Courts and an Andrew W. Mellon Foundation Fellow at the New York Historical Society. As Catherine mentioned, she was also a recipient of the MacArthur Fellowship from the Massachusetts Historical Society to conduct research on her new book. Her presentation on Threat of Dissent will explore the intersection of immigration law and the First Amendment, beginning with the Alien Friends Act of 1798 that was featured in our opening slide, and going on to look at the ways the government has used ideological exclusion and deportation of non-citizens to suppress dissent and radicalism throughout the 20th and 21st century, from the war on anarchy to the Cold War to the war on terror. So without further ado, I hope you will join me in welcoming Ms. Julia Rose Kraut.
Great to be here. Thank you so much. I am thrilled to return to the Massachusetts Historical Society, albeit virtually, and to talk about my book, Threat of Dissent. It was such a pleasure to do research at the Massachusetts Historical Society, and I just want to take the opportunity to thank Conrad Wright, Peter Drummy, and all of the librarians, archivists, and society staff who helped guide me and assist me during my fellowship. Made a difference, and we can't write books without archives and librarians and their guidance. And just want to again thank the Society for support of my research and work, and I'm just delighted to be here. So what I wanted to do this evening is talk a little bit about Threat of Dissent, about ideological exclusion, deportation in the United States, and share a little bit about my argument and some highlights and images along the way of this very long chronological narrative that begins with the Alien Friends Act of 1798 and ends with the War on Terror and the Trump administration. Now, when I say ideological exclusion and deportation, this is the expulsion and the barring of foreign non-citizen immigrants or visitors from the United States based on their political beliefs, expressions, and associations. There are a few types of such exclusions and deportations. Some are explicit, barring, for instance, anarchists or communists in the provisions of the laws. There are some that are implicit, so gives tremendous power and discretion to federal officials to bar based on what they perceive is the individual's threat to the United States, or might pose be prejudicial to the public interest through their presence in the United States. There's also retaliatory and selective exclusion and deportation, meaning that you might be excluded or deported based on some other justification, but the reason why is really because of what you say or what you do, or what affiliations you have or what you write. And so it's retaliation for your expression. So I work within those three categories to describe this type of barring and expulsion based on political expression, association, and ideas. And what I argue is that the passage of such restrictions and the enforcement by federal officials are done in the name of national security. And such exclusions and deportations are used as tools of political repression to suppress the threat of dissent, which I define as criticism of US politicians or policies, challenges to the status quo or capitalism, or calls for reform or revolution. And this has been an enduring tool of political repression that reflects a fear of subversion within the United States, internal subversion as well as threat of external subversion, and the conflation of radicals and dissenters with foreign non-citizens. This fear of the foreigner importing radicalism to the United States and then spreading it within the United States. Now, this tool of political repression endures for so long because, as I argue, that it has been interpreted by the majority of the Supreme Court as an immigration issue as opposed to a First Amendment law issue. And what that means is that the courts have applied immigration legal doctrine to cases of ideological exclusion and deportation. And this doctrine has helped insulate these cases from substantive judicial review and more speech protective First Amendment legal standards and strict scrutiny. Now, one of the reasons why it's very important, and what I did in this book, is to tell this story through such a long chronology, is because what I found through my research is that the use of ideological exclusion, deportation, reveals change over time, but especially reveals continuities over time and consistencies. And by taking this long view and tracing the continuity of particular laws over time, those who were excluded and deported over time, as well as organizations that have challenged these laws and their implementation, and federal officials who have sought to pass and enforce these laws, that you were able to trace kind of a thread through from 1798 all the way through the 20th century and into the 21st. You also see consistencies of argument for and against ideological exclusion and deportation, as well as references to the past and a situation within historical context. Now, ideological exclusion and deportation is, I found, firmly within the history of immigration and free speech and expression within the United States, but it seems to have fallen through the cracks of immigration and political repression, legal scholarship, and history scholarship. And so what I'm trying to do is tell this story, focusing on ideological exclusion and deportation, and showing how it fits firmly within the history of immigration and free expression within the United States. Now, I'm going to begin where I begin in chapter 1 with the Alien Friends Act of 1798. So let's take a look here. And this is what you saw at the beginning, the blank warrant signed by John Adams, authorizing deportation under the Alien Friends Act. And I still remember the day that Peter Drummey brought this out, because a copy of this is within the Massachusetts Historical Society collections under the Timothy Pickering papers. And I immediately saw it and said, I have to have an image of this for my book immediately. It's an incredible document. And the reason why it's incredible is because we don't hear much about the Alien Friends Act. We know that and what I describe in chapter 1 is that we have a very divided country on the brink of war with France by 1798, divided between Federalists and Democratic Republicans. And that there is a passage of a number of acts, including a Naturalization Act, extending the residency requirement from 5 years to 14 years. We have the Alien Enemies Act that's passed during the Adams administration, which calls for the detention and deportation of enemy aliens, those who were citizens of countries that we were at war with. And then you had the Sedition Act and the Alien Friends Act. And we know, and we're familiar with the Sedition Act and prosecutions under it that were targeted by a Federalist-dominated Congress and signed by John Adams that penalize those who shall write, print, or utter or publish false, scandalous, and malicious expression against the United States, the President, and Congress, with the intent to defame or bring into contempt or disrepute or excite hatred of the good people against them. So we're familiar with the Sedition Act, but the Alien Friends Act came along with it. And this gave John Adams, as president, the power to deport anyone whom he deemed dangerous to the peace and safety of the United States. It also allowed him to prevent deportations by permitting those to get a license from him that where he could deem them safe and that they did not pose a threat to the United States. There were also penalties, so that if you were ordered deported and you did not leave or tried to evade deportation, you could be in prison for 3 years. It called for the speedy removal if President Adams deemed it. And also that if you returned to the United States, if ordered deported and were unauthorized to return, you could face indefinite imprisonment until the president decided that you were no longer a danger to peace and safety. So this wasn't just kind of the power to deport. This is tremendous power, and it was unchecked power left to the discretion of the president. And I begin in 1798 because this Alien Friends Act is the first ideological deportation provision in the United States, and also shows how these provisions, and it's an implicit ideological deportation provision, leave so much power in the executive and so much unlimited, unchecked discretion in the executive to deport. And what we find is that there was resistance to this. And what I show in this chapter is not only the arguments against it, but also the arguments for its passage by Federalists, as well as attempts by Adams to use it with the urging of his Secretary of State, Timothy Pickering, in conjunction with the Sedition Act. Now, we often don't hear about the Alien Friends Act because Adams didn't deport under it. But what I show in the book, and what I learned through the research, is that it wasn't for lack of trying. There were certain circumstances where the Sedition Act was used to try to suppress, as opposed to using the Alien Friends Act. Or there were certain circumstances where people voluntarily left. But what you see here is that Adams signed a blank warrant with the intention of using it. And it's that power and the fear that led many French men and women to flee the United States in anticipation of this act's use. Now, the other thing that's very significant too about the Alien Friends Act, and what I demonstrate in this first chapter, is that the arguments for it are what are consistent with the arguments for ideological exclusion deportation in the name of national security, that this is necessary to protect and preserve and defend the United States. And that is what the Federalists are arguing. The Democratic Republicans have a number of arguments too, but say that really that this is something that in terms of restriction is not power left to the federal government, but really to the states. It's the states that regulate admission and deportation, and the federal government doesn't have power. Now, under the Constitution, there is no explicit reference to immigration and to the regulation of immigration, unlike naturalization, which Congress has the power to pass and regulate. So what the Federalists do in arguing for the passage of the Alien Friends Act is try to find places in the Constitution to hang its hat and to provide a constitutional underpinning and give the federal government power. They argue about the clause allowing Congress to regulate foreign commerce. They point to the 1808 migration clause, which the Democratic Republicans also argue, well, it's not 1808 yet. And then they also talk about national sovereignty and the right to self-preservation that every sovereign has. And so what's significant about that is that this national sovereignty and self-preservation argument is going to return again in the late 19th century as the primary justification for the federal government regulating immigration. Now, what happens with the Alien Friends Act really is that it's left to expire. But there were those like James Madison and Albert Gallatin who argued that this is really a violation of the separation of powers, that violates due process protections. The due process clause refers to persons as opposed to citizens. And there really is a tremendous problem and a threat here of having the executive hold so much unchecked absolute power. Now, we fast forward to the end of this chapter, and as we begin to get into ideological exclusion deportation, what you have is this movement from state regulation of immigration to federal regulation of immigration. And the Supreme Court upholds federal regulation by upholding the Chinese Exclusion Act. And the justification, again, is turning back to these old arguments of self-preservation and national sovereignty. And the court establishes something called the plenary power doctrine, which is that Congress holds the power to pass laws to exclude or deport. Federal officials have the power to implement and enforce those laws, and the judiciary should defer to Congress and to those federal officials. It's this judicial deference that insulates immigration law, exclusion and deportation from substantive judicial review. And what you find is that even today, the plenary power doctrine holds strong, as well as this judicial deference. And that's something that continues and is throughout the story of ideological exclusion, deportation. And that's what, as I argue, helps it to endure, to be used as a tool of political repression. So the Alien Friends Act plays a very important role, not only as the first ideological deportation law, but also as presenting the first arguments against ideological deportation and this tremendous power held by the executive, as well as the arguments for restriction and the underpinnings of the plenary power doctrine. You see over the course, one of the consistencies that I found through the research, and you see that I bring out in the book, is that the Alien Friends Act and the Sedition Act are considered the most repressive, draconian laws passed in United States history. And repeatedly, those who are challenging ideological exclusion and deportation always cite the Alien Friends Act and the Sedition Act in their challenges, saying, look at this new law, look at what it's doing. It's just like that tremendous power and discretion and the use of these laws as suppression tools to suppress dissent that we saw in the Alien Friends Act and the Sedition Act. So we see consistency in the use and reference to the Alien Friends Act, as well as those who are arguing in support of ideological exclusion, deportation, trying to distance themselves from the Alien Friends Act and the Sedition Act, saying, no, 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 these laws, these restrictions, nothing like that. And that's something that I bring out throughout the narrative. So when we get into the 20th century, we're ready with the plenary power doctrine to start to ideologically exclude. And let's see, here we have the war on anarchy, which I discuss in chapter 2. And we entered the 20th century with the assassination of President McKinley in 1901 by a self-proclaimed anarchist named Leon Czolgosz. And not only do we have the suppression of anarchists, their meetings, their speeches, their newspapers, but we also have this conflation of foreigners and radicals and the desire to exclude or deport. Now, Europe had already been in the war on anarchy with a slew of assassinations by anarchists of European leaders. And so the United States is a bit of a latecomer to suppression efforts. But ideological exclusion and a law in 1903, the Alien Immigration Act, excluding anarchists, is passed in response to the assassination of President McKinley. And if you can see here in this judge cartoon, you see the direct from the slums of Europe daily, the unrestricted dumping ground, that immigrants are depicted as rodents. In the center, we have an anarchist with the knife, which says assassination on it. And in the left-hand corner, we have President McKinley So the connection between the desire to exclude anarchists and this connection between foreigners and anarchism as importing radicalism and spreading it and leading to violence is very strong. Now, the connection between anarchists and violence began with the Haymarket affair in 1886 and again in the 1890s, but is solidified in the United States with the assassination of President McKinley, and then results in suppression along with the Alien Immigration Act. Now, you could be deported under this act, not only excluded, but deported 3 years after entry if you're found to be an anarchist. That's really important because what it does is it not only introduces ideological exclusion, but ideological deportation. And the focus of this is Emma Goldman. Now, Leon Czolgosz had mentioned the notorious anarchist leader as the woman who set him on fire through one of his speeches. Eventually this led him to assassinate McKinley. Now she's arrested, this is her mugshot. She's arrested shortly after the assassination, but there's no evidence that she in any way played a role in the assassination. Even Czolgosz said she had nothing to do with it, I acted alone. But there was a determination to get rid of Emma Goldman from the country. And this leads to her denaturalization by 1909. And she obtained citizenship. She was an immigrant from Lithuania, then part of the Russian Empire. And she got derivative citizenship through her marriage. And the government basically attacked her husband's citizenship, which was also derivative, by denaturalizing him, finding that it was obtained through fraud or misrepresentation. And thereby, by denaturalizing him, they denaturalized Emma Goldman. And that is important because that allows them to deport her. So denaturalization and deportation go hand in hand. And that's something to think about when we think about immigration restrictions and deportation. The desire and the move to denaturalize is often part of that in terms of deportation drives, and was key to deporting anarchist leader Emma Goldman, which I discuss in chapter 3. And in chapter 3, most people will have heard of the mass deportations after the Red Scare in 1919 and into 1920. Also, the suppression of anti-World War I protesters and dissenters, and then those who objected to the draft, as well as anarchists and members of the industrial workers of the world, the IWW, and often referred to as the Wobblies, as well as those who supported the Bolsheviks and the Russian Revolution and became members of early communist parties. And so there was a denaturalization and deportation drives during World War I to suppress dissent and to target radicals, but also particularly focusing on foreign radicals. And there were changes to the Alien Immigration Act. In 1917, it allowed for deportation within 5 years. And in 1918, through the Anarchist Exclusion Act, it allowed for deportation of those no matter how long they had been in the country. And it's through the Anarchist Exclusion Act that Emma Goldman and her comrade Alexander Berkman are deported in 1919 because of this expansion of the act with the help of A. Mitchell Palmer, the Attorney General, and a young man just getting started named J. Edgar Hoover, who was determined to get Emma Goldman out of the country. Now, A. Mitchell Palmer and J. Edgar Hoover are the ones who orchestrate massive raids and roundups of radicals in 1919 and 1920. and attempt to deport them. But there's one man standing in their way, and that is Louis Post. And Louis Post was someone who was the Assistant Secretary of Labor and was in control of who was deported and held the discretion to decide who would have to leave the United States and who could stay. And he used his interpretive discretion to interpret the law and prevent a lot of deportation, finding that a lot of these radicals did not fall under the definitions and the categories of the explicit Anarchist Exclusion Act, barring and authorizing the deportation of anarchists and subversives. And so it was through his interpretation and his ability to say, interpret membership in a particular way, or to see whether this radical really fell under the act, that he prevented a number of deportations. He could not prevent Emma Goldman or Alexander Berkman, but he prevented quite a few. And he came under fire and calls for his impeachment because of his exercise of interpretive discretion to prevent deportations. Now, what happens is that not only is this story about those who face deportations and federal officials who are pressing to deport or exclude, and those who are preventing them using their discretion to prevent it, but also a story of organizations. So the Free Speech League, which I described in chapter 2 with the anarchists, was the first free speech organization in the United States. And they are the precursor to the American Civil Liberties Union, who I introduce in this chapter, in chapter 3, and who also speak out, who are formed in 1920 and had out of organizations that have represented anti-war protesters and dissenters. And the ACLU is the one that calls out and is formed in part in a response to these massive ideological deportations, this deportations delirium, as Louis Post described them. And so free speech organizations and civil liberty organizations are part of this story, and ideological restrictions, exclusions, and deportations are part of the stories of civil liberties organizations. Now, in the 1930s, there's a focus on immigrants as a threat, not only as part of labor organizations, and there's tremendous concern about communist infiltration of labor organizations, but also there is a push to deport and to denaturalize during this time as a solution to unemployment during the Great Depression. This is where you have Mexican repatriation. This is also where you have massive efforts to not only close the borders, but also to deport and to denaturalize. And you have real concern about those who are facing deportation, including ideological deportation under the Anarchist Exclusion Act, being deported to be persecuted in fascist countries like Nazi Germany. And so there are efforts to prevent these deportations, and there's a new organization founded by the American Civil Liberties Union and the International Labor Defense Organization in 1933 forms the American Committee for Protection of Foreign Born, and they represent those facing deportation and denaturalization, including under the Anarchist Exclusion Act. And the General Counsel for the American Committee for Protection of Foreign Born by the 1940s is one of the most famous immigration attorneys in the country. That's Carol Weiss King. And Carol Weiss King is on the right-hand side of your screen, and one of her clients that I discuss in chapter 4 when I talk about the Great Depression is Harry Bridges, the Australian-born labor leader who is head of the West Coast CIO, and that's his daughter on the left. And he's in deportation hearings on Angel Island in 1939, because there's a determination by J. Edgar Hoover and by a congressman named Martin Dies from Texas, who is head of the House of Un-American Activities Committee, to deport Bridges. And while there were many efforts to deport, there were also those like who I mentioned, Lewis Post, who tried to prevent deportations. And the Secretary of Labor at the time, Frances Perkins, had tried to prevent or defer Harry Bridges' deportation under her interpretation of the Anarchist Exclusion Act. So again, we're using interpretive discretion by federal officials, some who are deporting more and some who are choosing to deport less. And like Post, Frances Perkins comes under fire for her decision, and there is a deportation hearing. And what the law states, and under Supreme Court decisions, is that under the Anarchist Exclusion Act, you have to be presently a member of a subversive organization, or the Communist Party in this case. There's a hearing, there's a determination that Harry Bridges is not a communist or a member of the Communist Party, and he's prevented from being deported. And Congress then passes a law. There's outrage. J. Edgar Hoover is outraged. Martin Dies is outraged. And Congress passes the Alien Registration Act in 1940, known as the Smith Act, that has provisions to suppress radicalism and dissent and members of subversive organizations, but also calls for exclusion and deportation, and revises the law to provide for deportation of present and past members of subversive organizations, in this case, including the Communist Party. And it's directly in response to the Bridges case. It goes to the Supreme Court again after an attempt to deport Harry Bridges under the Smith Act. And the Supreme Court holds that Harry Bridges actually has never been a member of the Communist Party, and is not deported even under the Smith Act. And what you find is that Carol Weiss King, a female attorney, the most famous immigration attorney in the United States, is part of this story and is often never heard about, not talked about, but it plays a crucial role in preventing deportations and representing those facing deportation from the 1930s and into the early 1950s. And so Bridges, as well as Carol Weiss King and Frances Perkins, is part of this story. I continue on in the long narrative we consider the McCarthy era, which was much more than Joseph McCarthy, but into the Cold War in the late 1940s and on through the 1950s into the 1960s in Chapter 5. And what you see is that the anti-communism and the efforts to denaturalize and deport in the 1930s continue after World War II and start back up again in the late 1940s as we enter the Cold War. You see this Herblock cartoon from 1949 talking about this, kind of looking at this hysteria and trying to put out liberty, trying to suppress. This is where you have the formation of blacklists and loyalty oaths and anti-communism in full swing, well before McCarthy and then through hearings after it. You have the use of the Smith Act to suppress dissent and to target members of the Communist Party, as well as members of Communist Front organizations and labor leaders who are affiliated with the Communist Party or allegedly. And then you also have ideological exclusion, ideological deportation, and denaturalization at this time, and new laws. So you have the Smith Act being used, And you also have the passage of the Internal Security Act of 1950, the McCarran Act, and the Immigration and Nationality Act of 1952, known as the McCarran-Walter Act. And both have provisions that explicitly exclude or deport those advocating world communism and members of the Communist Party. And so building on the Smith Act and then with these new laws, Chapter 5 discusses the exclusions and deportations and Carol Weiss King's effort to prevent deportations. And so there's a lot of efforts to use ideological exclusion and deportation as tools of political repression at this time. And they continue to be used. Charlie Chaplin is involved with this. Graham Greene is involved with this. And Carlos Fuentes and Gabriel Garcia Marquez into the 1960s all face ideological exclusion. And there are those who were then set for deportation who had been in the United States for many, many years. We also see at this point a split where by the 1960s, the United States is beginning to, and the Supreme Court is beginning to provide more speech protection and roll back those, loyalty oaths and strike them down and guilt by association. But what remains is ideological exclusion deportation protected under the plenary power doctrine and upheld under the plenary power doctrine. As I'm kind of coming to the end here of my presentation, we start to begin to kind of shift a little bit in terms of this split. So ideological exclusion deportation survives immigration restriction, immigration reform in the 1960s, and is used by the Nixon administration in the 1970s. So it survives, those provisions survive. And they are used as part of Nixon administration's abuse of power and desire to suppress critics, to suppress dissenters, to suppress radicals on college campuses, and also those who threaten his re-election. So here's the Ernest Mandel case. And here what you have is Ernest Mandel is an academic, Belgian Marxist economist invited to the United States and barred. And what you have is also the use of some of this new First Amendment precedent to try to challenge his exclusion, not by claiming that immigrants who are seeking to enter or visitors seeking to enter who are non-citizens have constitutional rights, but rather that the exclusion of them violate Americans or those within the United States, their rights under the right to hear and the right to receive information under the First Amendment. And so this challenge goes up to the Supreme Court. And while the Supreme Court upholds Mandel's exclusion, it also provides a pathway to challenge exclusion that we still use today. That not that a newcomer, someone seeking entry, has rights, but the exclusion of that non-citizen violates our First Amendment right to hear and to receive information. Chapter 6 is one of the is the only examination of the Ernest Mandel case and the archival research and the background and using Freedom of Information Act. This is the first real look at the Ernest Mandel case and what's behind its decisions, the decision in that case. And so relying on archival research and the decisions and interpretation, this provides the very first glimpse and understanding of this case. Nixon administration also attempts to deport John Lennon, which is one of the retaliatory deportations that I mentioned before, concerned that Lennon's popularity would increase criticism of the Nixon administration and lead to his failure to be reelected. And there's also the exclusion of Shirley Graham Du Bois, W.E.B. Du Bois's widow at this time by the Nixon administration. By the 1980s, you have a real effort to try to repeal ideological exclusions, especially since there is an argument that these are antiquated laws and should no longer be used to exclude based on someone's beliefs, associations, and expressions. And so there's a major effort in the 1980s to repeal ideological exclusions and deportation laws led by Congressman Barney Frank and by the organization PEN America and the American Civil Liberties Union. There's actually what I depict in chapter 7 is this effort to repeal and the showdown between members of PEN America at its International Congress held in 1986, their conference, when they invite Secretary of State under the Reagan administration, George P. Shultz, who recently died, and his defense of the State Department's actions and kind of a contentious situation during that meeting between his presentation and PEN America. But what happens is there is success in repealing ideological exclusion deportation. At the same time, there's a shift from anti-communism to anti-terrorism. And what you find is that in the late 1980s through the 1990s and into the 21st century, these anti-terrorism provisions provide a backdoor to ideological exclusion and deportation through guilt by association and material support of terrorism provisions. By the end of this narrative, as you get into post 9/11 and the use of ideological exclusion under anti-terrorism provisions through older laws passed in the 1990s and newer laws like the USA Patriot Act, you have the exclusion, the ideological exclusion of scholars and academics under these anti-terrorism provisions, and who raised the argument that I had mentioned to you before of the fact that this is a form of censorship, that this is something that undermines the United States, and that it is a target, a use of immigration law as a tool of political repression, and that it is targeting not those who pose a threat, but those who might be critical of the United States, those who dissent, those who are challenging, those who are calling for revolutionary reform. When you get into the Trump administration, what you see is also a return to some of these exclusions or desire to exclude that we saw during the Cold War. In fact, during his campaign for President, Donald Trump introduced in 2016 extreme vetting, and he cited ideological screening tests from the Cold War as something he would want to do again. So where does that leave us now? Well, we have the Supreme Court upholding the travel ban, the Muslim ban, and employing the plenary power doctrine, the court deferring in the name of national security to the executive and tremendous power held by the executive. And then recently the repeal under the Biden administration. What you also have introduced during the Trump administration is more of the requirement to use social media handles as a part of the visa requirements, and the tremendous concern about what the United States is doing with that social media data, and could social media, your likes, your tweets, your retweets, be used against you at the border or during the visa process to exclude you. And there have been instances during the Trump administration of just that. What you also find is retaliatory deportations, and especially targeting those who were outspoken critics of the Trump administration and of its immigration policies. Alina Das of NYU Law, as well as Jordan Wells of the ACLU, the Brennan Center for Justice, the ACLU, as well as the Knight First Amendment Institute, all warned of the use of social media, but also this retaliatory deportations, selective deportations. And so what we have in Threat of Dissent is the history of what we see and are confronting now. While the Trump administration is over, what we are left with is immigration reform, as well as this concern about how social media is being used, the potential for ideological exclusion, deportation to come back, the use of the plenary power doctrine to insulate from substantive judicial review, as well as retaliatory deportations. Those are all things that we need to consider in addition to this history. And so I will stop there, and hopefully we'll have some more times for questions and discussion.
Great. Well, thank you very much for a wonderful presentation. And I'd like to just let our audience know that we use the Q&A function if you have questions. So we will try to get to as many as we can, but just type them into the Q&A function and we'll go through the ones that we're able to. So an anonymous attendee wrote, it seems from your book and US history that levels of ideological repression ebbs and flow over time. Were there any factors such as heightened nativism, economics, political unrest, etc., continually present at the start of each wave that signaled another round of ideological repressive legislation starting? I guess that's looking for a through line from each of them.
Right, and that's something that I try to bring up with this narrative, and by tracing the laws through as well as these particular moments in time. So as I saw kind of what I tried to do with the slides, as well as kind of citing the chapters, is that we see during these particular moments over the course of the 20th century and into the 21st, and going back to 1798, where there is kind of a heightened concern. There is a kind of a feeling of national insecurity, but that these laws kind of continue. And while there might seem like there's an ebb and flow, there's not really quite an ebb. It's always present and it endures. And one of my arguments is that we need to really kind of trace the law through. And while we have that there are these moments where particular groups are being targeted, it doesn't necessarily mean that these deportations or exclusions are stopping. And also, it really kind of depends on where the power is held and how it's used, the Nixon administration being one of them. That was not necessarily a part kind of a heightened, anti-communism per se. There was concern about radicalism at that time, but this really was an example among many of Nixon's abuse of power. And the Nixon administration's use at that time to target particular individuals and to use its power in specific ways. And that's what we see with the Lenin deportation effort. And that's what we also see with Ernest Mandel. But I think that as you go by decade, there are going to be definitely points of concern. But what continues is the law, the use of the law, and the revision of that law over time. And that's what I found kind of in tracing through and finding that line.
So we have a question from a somewhat unusual username. It says, Library of Congress Professional Guild AFSCME Local 2910. Okay. So I suspect it's not the entire guild. Says, Emma Goldman is, of course, a famous example. Do you have any sense of how many immigrants, especially naturalized immigrants, were actually deported for ideological reasons and how that varied over time?
Okay, so I provide some of those numbers in the book. And what I would say is that one of my conclusions is this is really not about numbers per se. There were not necessarily massive numbers in the grand scheme of things that were deported or excluded. There were quite a few, especially in those years kind of during the Cold War in the 1950s. And also in the 1920s. But it's not really a numbers game. And there are also problems with deportation because the other country that you're deporting to has to accept those that you're deporting. If they close their borders, then you can't really deport. And so there were a lot of instances where people were detained or under supervisory or conditional parole in the United States because they couldn't be deported. And there were increasing hurdles to deportation and denaturalization that the Supreme Court and ended up holding and creating in the 1950s and 1960s, not so much with ideological exclusion, but during this time with deportation and denaturalization. So it's not about numbers, it is about fear. And this is the problem. This is one of the things that's also very important going back to the Alien Friends Act, which is even if the effort isn't successful, even if the laws aren't used terribly frequently, it's the fear, the speech chilling, those who feel inhibited to speak or to express themselves or to join particular groups, and this guilt by association, or those who actually voluntarily or consider kind of being intimidated who leave or who don't even apply to come. And so one of the things that I bring up in the book are there are many people who didn't want to be examined about their affiliations and their expressions. There was an examination in the 1950s where you had to, for the past 15 years, declare all your associations and be questioned about it. Some people didn't even want to go through that. It was humiliating. Or to enter under a conditional visa where it limited, what you could do and how long you could stay. Gabriel Garcia Marquez refused to come because he didn't want to come under a conditional visa. And so that's something that you can't get from the numbers. That's something we have to say, this is unique. This is an intersection of First Amendment and immigration law. And this is something really about fear, intimidation, and how people no longer felt free to associate, to express themselves, to write in the United States, and also those trying to come to the United States. And so that's really what this is about, and often gets kind of lost when we're talking about immigration history as well as First Amendment history.
Aaron wrote, please connect these acts with the contemporary movements, labor and anti-war, that were going on. Were these movements the real targets?
Okay, so labor, and so in terms of, this was all part of the suppression efforts. So in terms of suppressing labor, so targeting the IWW and during World War I and afterwards, as well as radicals, they were using lots of different laws. Those who were within the United States who were citizens, they were being suppressed, but this was another tool as part of that. In the 1930s, there was the targeting and real concern about communist infiltration in groups within the United States, including the labor movement. There was attacks and investigations of labor leaders, but this ideological deportation and denaturalization was a tool and part of those efforts. The same thing with kind of McCarthyism and in the 1950s and 60s, and then further into the Cold War to the end, and now part of anti-terrorism and the war on terror. So it's all part of the same. When we think about this in terms of suppression efforts, you need to include exclusion and deportation and the laws under them, but they should be seen kind of together. Now, what's interesting, why I bring up Mandel, is we have more speech protective tests today than we did in 1920, okay? And what we see is that, by 1969, we have the right to receive information, right to hear, and we have more speech protection and legal precedent. Doesn't apply to ideological exclusion. The current test which was developed under that Ernest Mandel case, which goes to the Supreme Court. The Supreme Court, under a decision by Harry Blackman, states that you need a facially legitimate and bona fide reason to exclude. And this is way lower than any First Amendment precedent. And so what you have this kind of this insulation I was describing, the application of the plenary power doctrine, this judicial deference in the name of national security and to immigration restrictions and their implementation by the executive and by Congress. There's that deference to that. But then you have a standard that's well below what is applied in First Amendment cases and protection. And that's what permits it to endure, is that when it comes to ideological exclusion, we are not holding it to the same standard that we would be held to those within the United States and suppression efforts.
I think that we probably have time for just probably one more question, just keeping an eye on the time.
Yeah.
So Sarah wrote, in what ways have the Alien Enemies Act, etc., been used to justify restraining or imprisoning on US grounds rather than strictly deporting? So I think that that could certainly be talking about Japanese internment during World War II and things along those lines.
Okay, so then we have this act. We had when I started, we had the Naturalization Act along with the Alien Friends Act and Sedition Act, as well as the Alien Enemies Act. Alien Friends Act, Sedition Act are left to expire. Naturalization is altered and kind of reverted back to 5 years from 14. By 1802, but Alien Enemies Act remains. It's used, I believe, in 1812, and then it is used in World War I. And we still have versions of this to detain. Now we have the executive order that Roosevelt signs is kind of similar, but not this. But that's still something to kind of think about in terms of that these acts are still live, as is the Espionage Act today, which is used against whistleblowers. So,
well, great. I think that we're just about at 6:30, and I want to be conscious of people's time. I know many people would need to get to dinner, but thank you very much for a wonderful presentation. And I think Catherine is here to say a word as well.
I just want to say how happy we are to welcome you home and how proud we are to be part of your amazing success. Congratulations, Julia.
Okay, thank you so much. Thank you. It's been a pleasure. And again, thank you to all the librarians, archivists, and staff of the Massachusetts Historical Society. And thank you for inviting me to join me today.
Oh, you're warming their hearts.
People are interested in learning more. We hope that they'll buy a copy of the book. We recommend you going through bookshop.org, which supports locally owned bookstores. But of course, wherever you choose to buy books, we're happy with. So I hope everyone has a good evening. Good night.